Hi, everybody. This is panel 4, Understanding the Rules. This is your chance to get up close and personal with Reg BI. I'd like to thank the prior panels for setting up some of this so well. And even though this is the Down in the Weeds panel, please don't start checking your email. We are trying to make this as interactive as possible. My name is Diane Blizzard. I recently retired from the SEC after 18 years of service. Most recently, I was the Associate Director in the Rulemaking Office of the Division of Investment Management, and that's the division that's responsible for the regulation of investment companies and investment advisors. To my immediate right is Sarah Siethoff, who is my successor in that role. As such, she leads the development of policy and rulemaking initiatives relating to investment companies and investment advisors that we present to the Commission for their consideration. Sarah played an influential role in the development of Form CRS and the Commission's interpretations regarding the fiduciary duties owed by investment advisors and the solely incidental prong of broker-dealer exclusion from the definition of investment. To Sarah's right, we have Jennifer Morton. She's a partner at Shearman in Sterling, where she provides advice to market participants around the world with respect to U.S. regulation of broker-dealers, alternative trading systems, clearing agencies, and exchanges. To my left is Emily Russell. Emily was recently named Chief Counsel in the Division of Trading and Markets. I'll defer.
Oh, thank you.
After serving as a member of that office for more than a decade. Emily was a key driver of Reg BI within the Commission as a staff member and has been an invaluable spokesman for the Commission in explaining the rationale and purpose behind the regulation. And finally, we have Christopher Gilkerson, who is Senior Vice President, Chief Legal Officer, and General Counsel at Charles Schwab, where he is in charge of both institutional and retail legal groups. Prior to joining Schwab, Christopher was Assistant General Counsel for Market Regulation at the SEC, so he's got some SEC bona fides. And we're just going to jump right in because we have got a lot to cover here. I think, I just wanted to start off by saying that this really is an accomplishment that this rule made it out of the building. Sometimes you don't realize how much work it takes. And I think of this as a marathon that was done as a relay race from, staff members going back, including me. So thank you for making it to the finish line for us. We all sort of trailed along after you. But it is really quite an accomplishment. So we are going to, first, here you've got the best interest obligation up there for you, to consider the actual wording of the statute or the rule. And I think, what we're going to try and do in this panel is go through the general obligation, the best interest standard, plus all the subsidiary obligations where you can't comply with the best interest obligation unless you comply with all the subsidiary obligations, which strengthen and reinforce the rule. We're also going to basically treat this as a hot topics type of panel. The rule's been out for quite some time, and there are, people are quite familiar with it, but there are still some thorny issues, some things that are causing confusion that, we can hopefully elucidate a bit. So when we talk about the following issues with respect to this best interest obligation, really what we're talking about here are sort of scope issues. So when does the rule come into play? And I would just start off by asking Sarah and Emily if she wants to weigh in. Are people confused about the clients that are covered and not covered by Reg BI? The commission ended up adopting a pretty broad definition of who is a retail investor that is brought in under the rules. So it includes wealthy, sophisticated individuals that are natural persons, and it also includes legal representatives of those people, and people who you might ordinarily think of as accredited investors, sophisticated investors, that you may not be used to having that degree of care.
I can start with that. So the definition that we used, and we used the same definition, both regulation best interest and form CRS, so when you think about the package, at least you only have to think about it once, is we used the standard that was in the Dodd-Frank Act for a retail customer. So it certainly had a natural starting point, I think, on that. I think one of the benefits of that standard is it generally is quite clear who a natural person is. If they breathe, they meet this definition. And all of the other standards, I think sometimes I almost wish the commission, we would just use one standard. We do use slightly different standards depending on the purpose. But I think one of the beauties of it is its simplicity in that sense, that in terms of designing compliance systems and just making that base case decision, it's quite easy and something lots of firms, right, they're all collecting. They may not be collecting information on accredited investor status or other types of sophistication tests we sometimes use in the securities laws, but they certainly know whether they're dealing with an individual or not. So that part of it, even though some have said, why for very wealthy investors did you not carve them out, has not been a point of confusion. I think where we've gotten more questions is there is an aspect of it, a legal representative, that's part of that definition as well. And I think most of the questions have focused around that aspect of it, who gets captured by that, as well as, and I think we'll talk about this a little more later, sometimes you have layers that you're going through, and whether in going through that layers, the broker is giving advice to ultimately a retail investor, whether it counts or whether those layers sort of break the chain is where I think we've gotten the most questions. So I think this is an area where FAQs probably will ultimately provide some clarity, but this is honestly not a question that I think is unfamiliar to people who practice in this area. For example, for Form ADV for investment advisors, they often have to think of similar types of questions in terms of who is my client and whether these layers of intermediaries affect that for disclosures they have to deliver already to their clients. So some of these are questions that cover areas that we're familiar with.
And the one thing I would add is that from a broker-dealer perspective, the inclusion of these high net worth clients or customers, as Diane mentioned, is a change from existing suitability obligations. So Reg BI applies to a broader scope of retail customers than existing suitability in that way. In addition, on the legal rep point, I think one nuance there that we're also thinking through is, who's a legal rep? Are you in or out if you're a non-professional or professional legal representative? And the release talks about non-professional, that a legal rep that's covered by the rule is really intended to capture non-professional legal representatives and not professionally regulated legal representatives, so a broker-dealer or an investment advisor.
Emily, now that I have you.
Yes.
A lot turns on whether you've made a recommendation. So there are a lot of consequences of that. So when does a conversation become a recommendation? I know the commission has published a couple of FAQs on this topic. Do you think there's any lingering confusion about this out there?
Well, when a recommendation is made and the release makes this clear, the evaluation of recommendation is consistent with existing FINRA and commission precedent on that point. So in a vacuum, it shouldn't be confusing to broker-dealers who should be very familiar with this concept of a recommendation. And really it's going to be a facts and circumstances analysis, a key factor of which, though, is whether there's a call to action. Are you calling an investor to action by your communication? And the more individually tailored the communication, the more likely it's going to be viewed as a recommendation. That being said, regulation best interest now has this account recommendation wrinkle. Regulation best interest applies not just to securities transactions and investment strategies, but investment strategies which include account recommendations. And that's a change from the FINRA suitability context. And as a result of that, there's been a number of questions about how does this concept of recommendation apply when you're making an account recommendation. And so the staff did issue FAQs addressing first, the scope of what an account recommendation is. And really, they're geared at clarifying that it's not just advisory versus brokerage, but that it applies to account recommendations generally, and there can be a host of brokerage accounts that may be recommended, and gives examples of those, and all of those would be covered by regulation best interest. The second area where we've had some questions is in the context of hire me communications. When I think we get the scenario of a cocktail party. What if I'm talking to someone there and I encourage them to hire me? Or what if I'm out on the golf course? And I think what the FAQs there really make clear is that whether or not a communication is subject to regulation best interest depends on whether it's a recommendation, not on the context or the location of that communication. So you need to think very carefully about whether, again, that communication is a call to action. And the FAQs try to give some clarity about circumstances where the staff sees these communications as being less likely to raise a recommendation. But again, depending on the facts and circumstances, I can see communications definitely falling into a recommendation.
So Christopher, Jen, this has got to be something that everybody's grappling with out there. It's a key interpretive issue. How are you doing with that?
Like Emily said, it clearly is something new and beyond suitability when it comes to account recommendations, not just in the rollover context. And I thought the FAQ was helpful for sure, but also, as Emily said, it's going to be facts and circumstances, and I think a lot of firms are grappling with all the different facts and circumstances that come up in conversations your FA might have about your firm, especially with the prospect. And when does that call to action kind of kick in? Because then you have to satisfy your care obligation, you have to deliver the disclosure, so there's a lot riding on it. So there are a lot of different use cases that firms have to go through to figure that out, to help design the right policies and procedures and supervision around that.
Yeah, and I've seen that a lot on my end. A lot of our clients call up and they say, a lot of times we're having these conversations on the golf course at coffee or in casual meetings, and how do we actually come up with a compliance program that'll actually affect the Reg BI requirements successfully. And yeah, so our clients are definitely becoming more over-inclusive with respect to what a recommendation looks like, or what it could look like, and what the potential marketing meetings could be and coming up. So they're definitely casting a wider net until there's more guidance. But for now, it's definitely an interpretive question.
And a further complication is, what do you do with duly registered people? They're potentially making recommendations as both a broker-dealer and an investment advisor, depending on the context.
Yeah, that's for sure. And for our dual representatives, hey, they're talking to a client or a prospective client. It could be either recommend a brokerage account or an advisory account. So they're really wearing both hats at the same time. And I think it's at least implicit that, hey, on the Advisors Act side, it also is a best interest type of conversation to recommend you open up an account. One thing I will say on the brokerage side, and here's where I diverged a little bit from the FAQ, it's not always going to be the case that you're actually recommending a strategy or a security when you're recommending opening up an account.
Come to me, right?
Because at Schwab, no matter what your goal is, you can open up an account and we can serve you well without going to that next step to recommend an investment strategy or a particular security. So it really has front-loaded in the conversation this concept of best interest in a way we didn't have before.
I would just add to that. So in the dual-hatted personnel category, most of our clients at Shearman are very large banks who already have existing policies and procedures governing the activity of both, on the RIA side and on the broker-dealer side. And as the implementation date comes up in June, they're definitely erring on the side that a dually registered person, dual-hatted person, is basically engaging in broker-dealer activity for purposes of Reg BI. If they're making a recommendation in a security or an investment strategy or an account opening.
Yeah, I just wanted to circle back to what we started, or we noted before, that broker-dealers often do provide services to institutions that serve retail investors or through layers of intermediaries. So I wanted to ask you, Jen, have you been struggling at all with when Reg BI and the obligation to deliver forms CRS applies when you have these sort of layers of people involved?
Oh, intermediaries, yeah. So, the guidance we've heard from the SEC, I think it was at the FINRA conference, is that even if there's an intermediary involved, it doesn't relieve the broker-dealer of the Reg BI compliance regime. And that's the guidance we're sharing, obviously, with our clients. So it really ties back to the origination, the genesis of the recommendation, and when the broker-dealer comes into play, and then the type of retail investor. So it goes back to is it a recommendation, a security or investment strategy? Is it a retail customer? Are they using it for personal or household purposes? So it really starts there. And then whoever you have involved, whether it's an executing broker, or clearing broker, or whatever it is, you're still on the hook for Reg BI, and that's how we're viewing it. But I welcome any thoughts you may have.
Yeah, I think we're going to move on now to the care obligation. So whether a broker-dealer has made a recommendation consistent with the care obligation, it's up here, I hope it's not too small, will be based on a consideration of all the facts and circumstances at the time the recommendation is made, and is based on concepts that were drawn from the fiduciary duty owed by investment advisors. So Emily, for about the 3,000th time that you've probably addressed this issue, so how is this going to be different from making a suitability determination?
Well, it's different in a number of ways. First of all, and I think one of the key enhancements, obviously we've been talking a lot about it already, is the application to account recommendations. Those are recommendations that often happen at critical moments of an investor's lifetime. Investment decision involves significant amount of assets, can be irrevocable, and so it's very key that those recommendations be covered, particularly when you hear about the suggestion that folks are just flipping over to advisory, et cetera. That's a key concern, obviously the commission, and that was a key enhancement. In addition, the expansion to cover implicit hold recommendations. So this notion that when a broker-dealer agrees to monitor a retail customer's account, any recommendations that result from that monitoring, including those that aren't communicated to the retail customer, what has been known as an implicit hold recommendation, are covered by regulation best interest. Obviously, the explicit requirement that broker-dealers act in the best interest of the retail customers and not place their interests ahead of the retail customers is a really key enhancement. And I would note, and Sarah probably will get into this a little bit later when she talks about the duty of care under the Advisors Act, but there was some discussion about the lack of definition of best interest under regulation best interest. And really that's reflective of, as I think a number of panelists have already mentioned today, the fact that whether or not a recommendation is in the best interest is a facts and circumstances determination. And there's really no one-size-fits-all model. So to allow that flexibility that, what's in the best interest of one may not necessarily be in the best interest of the other. And that's consistent with how that's approached under the Advisors Act, the fiduciary duty there. So I just wanted to make one little note there. In addition, the rule requires brokers to explicitly consider costs as part of making the recommendations. So again, picking up some of those themes about the importance of costs and recommendations and the incentives that they create. The rule addresses makes clear that it applies to a series of recommended transactions. So this quantitative suitability, as it's currently known, or where a broker, getting out a broker's incentive to churn, it applies regardless of whether or not a broker-dealer exercises actual or de facto control over the customer's account, which is a key enhancement from how suitability is applied today. And finally, it reflects the Commission's expectation that as part of developing a reasonable basis for making a recommendation to a retail customer, that the broker-dealer would consider reasonably available alternatives.
Yeah. So, Jen, The cost issue is elevated in the adoption. Do you feel the release has given enough guidance to people as to how they should be considering costs, or you feel any angst about it at all?
Well, we always could use more guidance, of course, but right now, because the care obligation is very similar to the reasonable basis suitability obligation under 2111, we're finding that clients are leveraging off of their existing framework for determining what's suitable and what's reasonable for a retail customer. Also, given that the time is coming up for June 2020, so they're just looking for ways to really fold into their existing framework. Cost is now a definitely huge factor when they come up with products and services for the customer and making a recommendation. I think that the lowest cost option is not required per se. I think is helpful in terms of the flexibility that associated persons have at a broker-dealer for coming up with different investment strategies and products and recommendations for their retail customers. I mean, that there's no obligation to choose the lowest cost option doesn't mean that they choose the highest cost option either. But it's definitely, I think, to answer your question, they're building within the existing framework of suitability and the reasonable basis analysis cost, and then seeing what the risk profile is and the investment strategy is for the client at the time. So it's also facts and circumstances.
So, I mean, this whole idea of not putting, the broker-dealer's interests ahead of the retail customer reminds me of when we were kids and we were on a seesaw. And, you always wanted to find that perfect individual where you could balance completely, and the seesaw was in both your best interests at that point. But I want to turn to Sarah just to talk about how the care obligation and what a broker-dealer has to consider differs, if at all, from what an advisor has to go through to satisfy its duty of care under the Advisors Act.
So I think honestly, the care obligations has more similarities than differences to the duty of care that an advisor has. And I think certainly we've often talked, the difference is at the point in time, they're pretty much the same. The difference is what it's applied to and the advisor's more relationship-based nature that it has. And I guess one thing I would say that I think is just a temporary difference is that the advisors have been living with this regime for a long time. So in terms of all the talk that we'd always like more guidance and we're curious to see how this will be applied by the commission, the advisor has had that history for decades, and so they just have much more knowledge out there as to how it applies to their actual business. So I was just listening to this discussion about cost, and advisors have had that consideration in satisfying their fiduciary duty for a long time. And it doesn't mean that every single person out there who works with an advisor has a portfolio that's just, an S&P 500 index fund in it, which is probably, if you just purely look at, expense ratios, one of the lowest cost features out there. It just means when they're putting them in other things, they're thinking about other factors. So I want some international in there, so I'm going to put some of that. And yes, that has a slightly higher expense ratio, but you need that diversification. I'm going to put some small cap exposure and some fixed income exposure. It just means they're thinking about those other factors that justify and support that advice. And advisors have been doing that for a long time, and now you're just going to see that play out on some of these areas in the broker side. But in terms of where the standard, you see some differences. Again, I mentioned just the different model. So advisors, what they typically offer is one most common, you're hiring me as your discretionary manager. You're sort of handing over the keys and saying, I want you to make the decisions for me. You don't call me. So a broker-dealer, they will make a recommendation to you, but you are accepting and agreeing to take that action. With an advisor, how the large majority work is discretionary asset management. You just sort of hand over and say, I want you to run my portfolio. That is just a different model. And how you apply that duty of care that's going to be through everything because they have just handed it over to you. Part also what comes with that is a difference in monitoring. As Emily mentioned, part of what's new with Reg BI is this implicit hold, where if you agree to monitor, then this applies. So that's a big difference. In broker world, you agree to monitor, and part of what we're doing here is requiring some clarity around that. In the relationship summary, they have to say whether or not they're going to monitor. I think that was in this morning's discussion about confusion, and I'm not sure how much this does for confusion. I actually think this is a huge important point. In all of those studies that were mentioned, going back to the first RAND study that was done, Commissioner Gallagher was mentioning that this morning, that was a key point of confusion, that they didn't understand whether their account was being monitored. That is a big difference between advisors and brokers. Brokers can agree to do some level of monitoring, but they don't have to, and a lot of them don't. Whereas advisors, if you are handing them the keys, they have to monitor your account. They have violated their fiduciary duty if they're not doing that. So that's a key distinction. We're requiring clarity on that, and we, under our world, we attach a fiduciary duty to that. And that is definitely a distinction. It's a distinction not driven, I would say, by the duty of care obligation, but applied to the model that they offer. But I do think the other thing that's important too, not to forget, and again, this goes back to the choice and the services, is that is expensive to say, I want you to have discretionary management and ongoing monitoring of my account at all times. That is a more expensive service to provide. And to get that, oftentimes advisors have account minimums. We will not manage your account unless you have at least, $100,000 of assets or some other amount. Again, area we're requiring clarity, they now have to disclose that in their relationship summary. Do we have an account minimum for you to have this type of account? Again, not something where I think there was great clarity. And that's a real distinction, again, between the two, is that choice is great, but you don't get the same services, for the exact same price across the board. And so I think one of those differences is, again, taking that same core standard, but reflecting these differences in the models and allowing the investor to say, well, I'd like some advice, but I don't have the amount of assets that I'm going to be able to afford that. So what advice is available to me? And we've tried to take these standards and take those core fiduciary principles and apply them in a way so that regardless of the type of advice you're able to access for that, you're going to have that same core principle apply, but you're also going to be able to get some level of advice.
Just shifting a little bit and quickly before we move on, I think one of the important aspects of this rule is that in order to have a reasonable basis to believe that a recommendation is a retail client's best interest, you have to consider reasonably available alternatives. And the release doesn't, and this came up a couple times in the morning sessions, but you don't have to consider all available alternatives. But how do you know, Christopher, when you've made a reasonable effort to look at alternatives?
Yeah, and let me answer that by underscoring a couple of key points that have been made. First of all, this care obligation goes well beyond suitability. I mean, it really has upped the standard of care for the brokerage industry. I think in the moment of the recommendation, in the moment of the transaction, it's the same standard. And I think a lot of people are choosing not to understand that by criticizing the rule. The fact is, broker-dealers, as Sarah said, provide a very different service when it comes to advice. They don't provide discretionary management. They don't do ongoing monitoring. That's the additional service somebody purchases when they contract with an investment advisor. Now, when it comes to the broker-dealer's care obligation, I think the requirement to look at reasonably available alternatives is another extension that goes beyond suitability. It's really fundamental to care. That's a challenge for a lot of firms. I work at a very large dual registrant, Charles Schwab. We believe we need to narrow the field for our FAs because we're open architecture. We offer thousands of mutual funds and ETFs and thousands of fixed income securities and equities. So a good way to do this is at a firm level to have recommendable lists that are based on objective factors. It's not objective factors. There's a conflict of interest. You better disclose it. But I think by narrowing it down for the FAs based on your research department and recommendable list, it's a really good way to go at this reasonably available alternative requirement.
Thanks. And Jen, you know, you don't have to document a recommendation, but there's some language in the release saying, well, maybe if it's a little outlandish, you should.
Yeah, so again, firms read that, we're reading it with them, we're advising them, and they're like, how are we going to comply with this on an effective level for compliance purposes? And they're erring on the side of definitely documenting recommendations, or at least having their associated persons send an email, put on the record of how they're coming up with a decision when they come up with a recommendation for a product or a strategy.
Yeah.
They just are, as a practical matter.
Yeah, and we may hear more about this in the compliance panel that comes after us.
Yes.
So this is, as you can see, getting more complicated because now you can barely read it. But this is another aspect of the regulation that is quite new from current practice. So the commission made statements in the release that, you know, broker-dealer is not required to provide conflict-free advice. I mean, how are you going to do that? You've got revenue streams. There are always going to be conflicts, like there are conflicts in the advisor
Right.
space.
I was going to say, everyone.
Aren't you proud of me for saying that?
I know,
There you
if you're
go.
compensated, you're conflicted, right? So you've got, it's not unique to
Right.
broker-dealers.
So, you know, basically what this is saying is that you have to identify, disclose, eliminate, or if you're not eliminating, you have to mitigate any incentives that would place, you know, a broker-dealer in a position where it was not putting, it would have an incentive not to put the interests of the retail client first. This conflict analysis has caused people to engage in an awful lot of work. But I wanted to turn to Sarah first and just say, you know, how is this different from the duty of loyalty owed by investment advisors? You know, you might want to address that statement from this morning about how, you know, there's concern that perhaps what we said about the advisor's responsibility is actually less than what people thought it was.
Yeah, so I guess on this, I just realized on this topic, I heard our SEC disclaimer said so many times this
yeah?
morning.
Oh
I
my
think
gosh,
I
I forgot
forgot for us to say
So
it.
everything you've said up till now is consistent with the conditions of the
So I'm disclosing my
We were embodying them
conflict.
briefly, yes.
I'll cover Emily and I both. Everything we're saying here is just us and not representing the rest of the
We were
commission.
just so excited to get to it.
Yes.
We couldn't believe ourselves.
I mean, I think the duty of loyalty, again, very similar to the conflict obligation under Reg BI. Again, I think there are some differences going back really to the business model that is at issue here. But I guess maybe before I get that, we focus mainly on regulation best interest and not in the fiduciary interpretation. And I heard so much discussion this morning that I didn't really think matched what we discussed in that fiduciary interpretation that maybe I realized maybe I need to take a step back and talk about what we said on the advisor's obligation in terms of conflicts. And I heard a lot of discussion this morning about advisors could just disclose away conflicts. And that certainly is not the view that we expressed in the interpretation. We talked that an advisor must make full and fair disclosure and obtain informed consent from their clients to that conflict. And what I heard lost a lot was the consent part. And that consent is really important because if a reasonable investor is not going to consent to that conflict, then it doesn't matter what your disclosure was. And if that disclosure was not sufficient to inform that investor of the conflict and the nature and the import of it to him, that also is not going to suffice under that standard. And so when I would hear these statements that, well, they can just sort of put everything in and it just wipes everything away, I don't think that really fairly characterizes, again, the example of, I'm going to steal all your money. First of all, and that would absolve them of that. Putting aside that, again, you can't disclose away fraud. Fraud always applies. I think disclosure plays an important role in disciplining. First of all, what advisor is going to say that? And a lot of what disclosure does is a prophylactic. You'd be surprised how many conflicts go away when an advisor is forced to disclose them. I think one of my colleagues I was sitting with said, how many of you
a
would have
disinfectant.
the same Google search history if you had to publish it for everybody in this room to look at? You probably might make some slightly different things if you had to tell everybody about it. And that is a big function of disclosure. It certainly is also important, we believe, for investors, but it also is a great disciplining tool. That there are things when somebody reads it, they said, you want to say you're doing what? And lo and behold, certain conflicts get handled. So that's one feature of it. But another feature is, you have to say that a reasonable investor would consent to that conflict. Again, the example of, I'm going to, give you terrible advice. What client is going to consent to that? So I do think you need to think through the full import. So when I heard that one distinction between the two standards is an advisor can disclose everything away and a broker can't, I do think that is a false dichotomy that was put up. But
go ahead.
Just getting to, sorry, I had to get a little bit of a diatribe because I heard too much of this morning. But I think, again, they just, even though they have the same definition of a conflict, the nature of their business model means they often just have different conflicts. So I do think some of the differences you see in the conflict obligation, for example, the one on sales contests, it's just reflecting a practice that, given the differential nature of how they're compensated, you just see some of these conflicts come up differently in the brokerage business versus the advisor business.
So getting back to Reg BI, one of the things people have to disclose now are any material limitations that they're placing on the products they make available. And Christopher, everybody puts limits on the products they make available. So how are you approaching this?
Yeah, like I said a minute ago, there's like a positive side of material limitations when you're trying to define a set of reasonable alternatives, right? But then also firms might limit what's available to proprietary products, obvious conflict of interest, and conflict of interest obligation relates to the others, including disclosure. You want to expose that to the market as well as to individual investors. It's one of the things that's really great about this rule. I mean, a lot of firms were disclosing their business practices, talking about their business practices. They want their clients to understand them. Other firms weren't. Now all firms are required to do that, so that's really important. I do think that just in terms of the overall relationship to the Advisors Act, I mean, dual registrants are trying to abide by both. And that is a real challenge for us when we talk about conflict of interest as well as the other obligations. And it's a theme we'll see as we're really getting into practical questions of how to comply with Reg BI, while also still being mindful of similar but not identical obligations under the Advisors Act.
Right. Well, a big part of what people have to undertake here is examining all their revenue streams, right? And the conflict of interest that arises from what they get for different products. Jen, how are people dealing with this and developing their policies and procedures?
Yeah, absolutely. So the first step that most of our clients are taking is evaluating their existing sales practices, and then the products that are within those sales practices, the suite of products, and then the compensation framework that's tied to those products. So they are all forming, most of them are forming basically corporate governance committees to address this triumvirate, if you will. So their sales practices and the products and the relationship of compensation and revenues generated in that triangle. And then honing in on, okay, so what do we need to mitigate, any sort of incentive that would be derivative of that relationship, and then making sure that they implement the right policies and procedures to basically reduce that threat.
Yeah.
So that's definitely.
I would note that the release in the FAQs have talked about how you might want to approach this. Do you have anything to add?
Yeah, I mean, I just would like to emphasize the importance of this obligation in case that you haven't already had that hit over your head a few times already. This is a key aspect of regulation best interest and really lines up with the Commission's goal of enhancing the quality of investor recommendations by reducing the level of conflicts and the impact they can have on the recommendation. And that's why in certain instances, the Commission says, disclosure may be an effective tool, But in these instances, when we're talking about associated person incentives, about when a firm creates a limited product menu, these are places where you're really having an outsized impact on the potential recommendations that could be made, and you need to do more than just disclose it. And you need to deal with, through mitigation or elimination. And so that's really an important point.
We felt that the FAQs did a nice job of setting examples of how to mitigate. So a lot of our firms are definitely looking to that for a guideline.
And the one thing I would highlight, because it comes up a few times, they're examples, right? They're the list and the release, there are examples. I think over time I've heard a lot about, oh my God, do we have to do neutral factors? No, it's a non-exhaustive list. It's exemplary. And it's a kicking off point for your discussions. I know I and others on the staff would be really interested in hearing how firms are mitigating, and that's why it's great to have these conversations.
Yeah, and another plug for the compliance panel coming after hours. I think they're going to be discussing some of these issues. It really goes to the heart of the rule, in my opinion.
One just quick comment. I mean, the biggest conflict is how the advice giver gets paid. That is the biggest conflict above all. And, I really appreciate, because I'm a big fan of competition, that the commission has allowed firms to still determine the ways they compensate their representatives, although they have to mitigate any conflicts of interest that could impact the client's best interests. But, a real hope here is that how FAs get paid at different firms will become, top of mind for retail investors, because that's going to impact their advice almost more than anything else. I mean, it's just human nature and behavior.
Well, keeping us on schedule here, going to the disclosure obligation. And the first line there, you should pay particular attention to, because it is a separate obligation from delivering Form CRS. It's actually quite an onerous amount of things that people are going to have to really grapple with. What are the material facts about their conflicts and the relationship with you that they need to disclose to you? And it is relatively new that these are coming into play. So Jen, how, I think one of the big issues here will be, how is a firm going to know which conflicts they can disclose and which they should eliminate or mitigate? Did the FAQ on this help?
Okay, so let me kick it off with, so firms are already evaluating, obviously, their compensation structures, and basically, as Chris was pointing out, the genesis of the conflict really is how they're getting paid. And so now they're just looking at ways to mitigate. I think the category of elimination really comes from manipulative sales practices or sales competitions, which historically have been eliminated. And there's not a lot that falls in that category our firms are finding. But the mitigation is huge. And we do find the FAQs and the examples that you guys came up with to be tremendously helpful when they come up with their compliance regime. So they're reviewing, they're forming committees, sales practices coupled with the products they're offering and limitations on the products, and then seeing how they're compensating, and then dialing it down and trying to shift to mitigate the conflict.
Right, now the disclosure obligation here is, it anticipates written disclosure. There was a statement in the release that sort of provided a little wiggle room for providing the disclosure after the recommendation under certain very limited circumstances, and providing oral disclosure also under limited circumstances. And I think the commission released an FAQ basically saying, we mean limited.
Yeah, that's right. It is very limited circumstances. I think there had been some misconceptions about the extent of the relief given, and really this is intended to recognize the business realities of a transaction, and that in certain instances, limited instances, oral disclosure can be appropriate, or reliance on pre-existing disclosure provided under existing regulatory requirements. And the idea here is that you can't just get rid of your whole disclosure obligation through oral disclosure or reliance on these pre-existing documents. You need to first give a written disclosure that summarizes the material fact that you're going to give further disclosure on, either in later documents or orally. You need to describe how you're going to give more information orally or in another document. And then if you do it orally, you need to maintain a record of the fact that you gave that oral disclosure. And again, just to emphasize, using pre-existing regulatory requirements such as the prospectus or I think the trade confirm are examples, they're not going to meet the entirety of your disclosure obligation. So just keep that all in mind.
But nice segue to the next question. The commission did anticipate that, you wouldn't have to reinvent the wheel on this, and that there's a role here for layered disclosure.
Right, yeah, no, so layered disclosure, and I think that is basically what people were kicking around for most of the morning here, is this concept that, not everyone wants to receive the same level of information or wants to dig into the same level of documentation. That's something we've heard over and over, I think, as we considered this issue. And so the release provides flexibility. Yes, you can provide layered disclosure. You can provide initial standardized disclosure document and then supplement it with later disclosure. And the idea here is that this will kind of give flexibility to investors so they get the information they want and need to have in the way that suits them. And so that is a key aspect. And it's in alignment with what the Commission was trying to achieve with Form CRS. If you think about the relationship summary in conjunction with regulation best interest, the relationship summary is kind of an initial introductory document, and regulation best interest builds upon that.
So are there any do's and don'ts you want to highlight? I mean, in terms of, just hyperlinking everything and your Form CRS and saying, okay, I'm done.
Well, the Commission said the delivery could be given consistent with the existing electronic guidance.
Right.
So.
There's a lot in the FAQs. You can find the FAQs on the Commission's website. They address a lot of the kind of nitty-gritty issues here.
That's right. I mean, one thing I would say is the Commission makes clear there, while it's going to depend on the facts and circumstances, your relationship summary generally is not going to have enough disclosure to meet your regulation best interest disclosure obligation, and you're going to need to provide additional information. There's one exception that the Commission notes for a standalone broker-dealer when disclosing the capacity in which they're acting. Generally, they should be in a position that they can rely on the Form CRS to make that disclosure. But in most cases, more information is going to be needed. So please don't just rely on that relationship summary.
Right. And Christopher, I'm sure firms are applying, sort of looking at this. What should I put, in my, my first layer versus my second layer? I mean, how are you dealing with that?
Yeah, I mean, the Reg BI disclosure, I think, is a bit of an experimentation by the SEC. It's not as prescriptive, obviously, as Form CRS, which itself has some flexibility. But that's a blessing and a curse for firms because a lot of us have pre-existing disclosures and we'll clearly want to incorporate them and link to them. We want to use layered disclosure. We all will have failed if these rules just become a disclosure dump on retail investors. So we have to be really careful about our first layer, plain English and all of that. But if you look at what has to be in the disclosure, you are going to have to spill some ink, so to speak, to just have that first layer cover the items under the disclosure obligation, and then really rely on your second layer to link to things like your pricing guide, how you pay your representatives, more detail on your conflicts of interest, and of course you're going to want to link to just your account agreements because that has a lot of the material terms of the relationship. So I think there's a template there for firms to use, but I think we'll see some variability in how firms actually implement it.
And for that reason, it serves as a roadmap, if you will, right? It sets forth a framework where you can get some high-level description, one-off, but then you can get a deeper dive in the cross-reference disclosure that's already existing.
I mean, obviously, go ahead.
I was just going to say, I think we're actually interested in seeing this because as Christopher said, this is actually one area where I think advisor regulation is more prescriptive. We have a brochure, Form ADV brochure, that's required for advisors where we have a long list of items of specific disclosures that they must provide in it. Whereas in this instance, Reg BI, I think, went on a more principles basis and said you need to cover these broad areas, but much less specificity in exactly how they do it. So I think we are curious to see how, once all of these disclosures start coming out, how the Reg BI disclosures start looking compared to what investment advisor clients get through an ADV brochure.
And we had the ability to be more flexible at Reg BI. I mean, as you know, there's a lot of disclosure that's already out there, and we were trying to avoid some of the voluminous disclosure that is currently existing, again, disclosure overload, and some of those concepts that have been teed up today were very much at the forefront of our mind as we were considering these issues.
Yeah, I mean, obviously, you want something that investors are going to respond to that's going to make sense to them, and I'm sure that's the main thing you're thinking about. You don't want all your customers saying, why am I getting all this information?
Yeah, I mean, the disclosure obligation is a way to highlight for retail investors, you should be thinking about these 4 or 5 things, and here's where you go to get more information. I'll say the same thing when we get to CRS. It's a mistake for firms to let their lawyers and their compliance people write these things. Of course, we're going to be involved to make sure it meets the requirements, but get your marketing team involved. This needs to speak to investors, and I don't want it to look like a prospectus, quite honestly.
Right. Yeah, I mean, it's a great opportunity, really, when you think about it. Moving along, we wanted to put the compliance obligation up here for you to see because it's an important part of the rule. We're not going to spend a lot of time on it because we have a compliance panel coming right afterwards, but didn't want to leave it out.
Compliance is important.
It is,
Yes.
yes.
So we're going to move along to the Form CRS and the relationship summary, which you've heard about a bit, but we wanted to go into it a little bit more in depth. So in the proposal, the CRS was more prescribed. There was a lot more sort of, this is what you're going to say in your Form CS. Everybody's going to basically describe all of this similarly. And I think when looking at the comments, the commission realized that, nobody's going to be happy if you're prescribing, their language with that much specificity. So they gave a lot more flexibility to people to provide the disclosure in a way that they think will be most meaningful. So, Christopher, I'm curious if you could just get into a little bit more detail about how you're approaching what you're going to include in your relationship summary.
Sure. Well, Schwab wrote 3 comment letters on the Form CRS because we think it's a really important part of the package. And I think it came a long way from the proposed Form CRS to the final form that was adopted. Really appreciate that the staff listened to our comments and a lot of other comments as well. I'm not sure it's going to be a perfect document. There's still a lot of language that's prescribed, and so part of it's going to look like boilerplate, but there's still enough room and flexibility if you follow the instructions. Hey, there are 18 pages of instructions. There's a lot of guidance there. To have your firm tell their story in the Form CRS while still meeting the requirements, and that's going to be a really important thing. And I've already heard at this conference people being dismissive, disclosure's not the way to go. It's a relationship summary. I think it's wrong for us to think about it as a disclosure alone, and digital has a great promise here. Digital is a way to make the template work and to draw in an investor and to engage them with how you conduct business. And I hope it becomes a comparative document. Again, I'm all for competition. This should be one way that firms are able to compete with one another. And it may take a number of years to have retail investors get used to this document. But maybe I'm overly optimistic, but I think there's some hope here for that document.
I mean, as a practical matter, it's hard to become a disclosure document on its face due to the 2- and 4-page limitation. I think that's why it's structured in that regard, right? So the layering is very helpful, and the electronic ability is very important too. So I agree with you, but I think to become a full disclosure document, I just don't think it's achievable in the first instance.
I mean, the commission has so many times heard from so many people that shorter is better when it comes to these types of disclosure documents, and that, anything of any length is going to be discarded by investors. Jen, do you think that it's going to fulfill its purpose for being an informative way to compare firms? It's really all about being able to compare firms and decide what's the best choice for you.
Yeah, that's a great question. I think as a practical matter, the framework that the SEC has asked us to use this form, I think it'll give some high levels, and it'll give a framework, like I keep saying, among the firms. I think the firms are also going to look at each other and what they're going to be doing and comparing and adding and supplementing and saying, oh, that's a really good idea. But I think that's TBD. I think we'll see how it evolves over time, but I think in the first instance, I think it's going to be a lot of layering, a lot of cross-referencing. It will have a summary that people can compare, but whether or not that evolves over time, will probably the answer is yes.
Sarah, there was great disappointment when the FAQ came out and basically said to people, even though you're a big, complex firm with all these different, services that you provide investors, unlike with, the different brochures, you can only have one. And it's sort of harkened back, 1-2 page, unless you're a dual registrant, then you've got choices. And you can either have separate ones for your broker and your advisory business, or you can have a 4-page combined one. So I think there are a lot of people out there that want you to revisit this. And I think that they really are genuinely concerned that they're not going to be able to really effectively communicate a big, complex, investment firm in 2 pages. So how do you say anything and make them feel better?
I mean, I think, again, the goal here was to have a very short summary type document with links to lead people to more information. And I think we felt like it would have defeated that purpose if you had allowed separate, you could have firms that have 10 or 15 different relationship summaries and they stack them up and hand them all over. And then what have you really advanced in terms of distilling down in a layered framework for people? And honestly, we see the form ADVs for some of these firms who offer tons of different offerings, and they're like 100 pages long. I mean, what investor really is going to wade through all of that? I'm sure some intrepid ones out there who do that, but a lot of them are not. And I will say the one thing being in this space is you got to have a good dose of humility to be here, because let me tell you, any disclosure we put out was not going to satisfy everyone. It's always about trade-offs, and we're trying to do the best we can, but you always could argue over whether we distilled the right exact points to highlight. Did we balance them correctly? There's always the debate over we gave them too much flexibility, but then if we made it more mandated, everybody would have said, well, you just made it boilerplate that no one's going to read. How many people read those privacy forms you get when you go to the doctor's office? So there is, we are trying to balance all those goals, but we do recognize that this is an experiment, and we'll go out with it and hopefully learn. And we've got all these researchers can go now run these experiments with it and tell us how they're working. I think we also hope, this is a structured form with standard questions that are going to have to be answered. So third-party aggregators hopefully can get out there and aggregate some of this information. I think that was not so readily done before. Maybe you can get some information, and if there are better ways to distill it, maybe they can show some creative ways of doing it. So I think there are lots of ways of looking at this that hopefully we'll get to a good result. But I do think we thought that proliferating more of these would not necessarily lead to the result we were searching.
Diane, may I follow up with Sarah? I love that we're trying not to proliferate too many form CRS, because our industry is not this simple dichotomy. Oh, you can get advice in a brokerage account, or you can get advice in an advisory account. We have advisors who hire or recommend custodians. We've got managed account platforms that have third-party money managers on the platform that the sponsor might recommend to their client. So one thing we're missing is sort of a unifying principle that maybe it should be the broker-dealer advisor with the primary relationship whose service is being considered by that retail customer. We'll get you in a minute. Whose service is being considered by the retail customer who delivers their form CRS, rather than having to then deliver, now I need to get the custodian CRS, and now I need to get that third-party money manager's CRS to you as well. And there are a couple of pending FAQs at the SEC on that. And so I think the avoiding proliferation rationale is a really good one to apply to those other situations too.
Yep, nothing like getting lobbied up on the stage.
Why not?
I mean, I do think, I'm sure more FAQs will be coming. We certainly have had a number of questions in these areas. I'm not going to give a spoiler on how we may answer some of these questions, but I do think we are answering the questions with the spirit of the goals in mind of succinct disclosure aimed at the core services of advice that brokers and investment advisors can offer. So hopefully it will keep that core spirit, even if whether or not you ultimately agree with us on what we say on some of these topics.
Very carefully said, but thank you.
Yeah. I mean, one issue people have been talking about is, who delivers what. If you're, in an SMA program, does the portfolio manager deliver a CRS? Does the sponsor of the wrap program deliver a CRS? So, I mean, I think that this is kind of the type of things that can be addressed effectively in FAQs, and I imagine we'll probably be seeing more. Anybody else have any?
I just want to mention, you'll all be looking at your conference materials, I'm sure. Included in there is a practical guide to preparing your Form CRS. Might be valuable for a lot of firms. Schwab provided that through our advisor services business. So it's in the materials, and just shows that when you go through all the instructions and the form that it's pretty clear how you do that, and there is that in the conference materials.
I think the other thing I should say is that one thing the commission did commit to do when it passed this package was to go back, after you've got a little time in place and all of these relationship summaries are out there, and have a look and see how firms have decided to implement them and whether it really is serving the goals that the commission was seeking there. So I don't know exactly how the results of that will come out, whether it'll be, something sort of observations from the staff or things like that. But, I think we are committed whenever we do a new form like this to holding ourselves accountable and going back and look and seeing how it played out and whether it really achieved what we were looking for.
To that point, we saw this in the ATSN, the new ATSN form. We saw that the staff came out and started reviewing what people were doing. So, yeah, support that. I think that's right.
Yeah, so the FAQs are dealing with a lot of the nitty-gritty issues here that you will all be considering, such as the timing and delivery mechanisms for delivering to new investors versus existing directors. They clarified that you don't need to deliver CRS to investors in private funds. There are all kinds of good information there, so if you haven't looked at the FAQs, I encourage you to do that. Anybody have anything else, or we might just see if anyone has any questions? We've been asked to reserve some time. I'm not going to threaten you like Jason. Why? But you do have a great panel up here, so if anybody has any questions, we're really happy to take them. Okay. Can we get a microphone up here?
While we wait for that, I would plug that both the staff put out compliance guides on both regulation best interest and Form CRS. So for those of you, I think there were a few wise remarks made over the course of the day about the length of the releases and the weight that there may be, that they may encumber on you. So I would suggest you look at those. They're great synopsises of the rule.
Yeah, I agree. I mean, you can save yourself from reading all that.
Well, no, let's not go crazy. There's
let's
lots
just
of
say
stuff
it's a
in
good
there.
starting point.
It's great prose.
Yeah. It's a Cliff Notes version.
It's a Cliff Notes.
It's a relationship summary.
That's right. Layered disclosure.
So in talking about CRS and the Reg BI disclosure obligation, it was interesting to hear you say, they're really intended together. Firms have more flexibility on the Reg BI, but have you thought about, or do you have any expectations that CRS and Reg BI go together? Or no, do you have an expectation that investors...
When they're delivered, you mean?
Yeah. Investors will see the Reg BI disclosure more than they see the Form CRS?
Well, I think this goes to an important point, which is, I think, and Sarah can talk more broadly, but Reg BI is triggered by a recommendation, right? Your delivery obligations under Form CRS are in a broader context of situations, and not just limited to a recommendation. I think it's when a customer opens an account or when a broker is going to place a trade. So it's a broader context of circumstances when you're going to get the relationship summary. And again, that goes to what it's intended to get at, which is to be this gating document to help you make a decision. Whereas regulation best interest comes in, okay, I've got a relationship with someone and now I'm receiving a recommendation and I'm going to use it, and here's the relevant disclosures I would need to have.
Okay, we have someone in the back.
Hi, Ken Joseph from Duff & Phelps. Thank you so much for the presentation. I have a two-part question. One is on, if you can say a few words on the duty to update, when it's triggered, if it's triggered. And then secondly, with regards to the materiality considerations, as all of you know, materiality is often judged in hindsight. And I'm trying to figure out whether you have any guidance on how one can do the materiality assessment successfully.
And the duty update, is that Form CRS?
Yeah, well, I think one goes to Sarah and one goes to Emily. The duty to update the.
Are you talking about
The
when you
CRS
have
or-
to redeliver
Yes.
Form CRS?
Yeah.
So I think it's triggered when there's something new. For example, if you're going to open an additional account for the client or customer, you would have to deliver another Form CRS. If you were going to make a big change in the terms of that, you would deliver another Form CRS. So I don't, it doesn't detail every single circumstance that could lead to that. Or say, for example, you were going to recommend that they roll over a whole additional set of assets into one of the accounts, that would re-trigger another delivery. So it's basically more material events that would say something is about to change here, and so it might be a good time to remind you of the key features of my services, my cost, my conflicts.
And whether something is material under Reg BI for a disclosure obligation, the Commission interpreted materiality consistent with existing precedent under Basic v. Levinson, so whether a reasonable investor would be expected to consider it important to their investment decisions. So that's the standard that the Commission is applying to determining whether or not a fact needs to be disclosed under regulation best interest.
That's what I'm struggling with. The standard on the existing regime is that of a reasonable investor, but the form is really targeted to the specific investor. So I'm not sure.
Right, yeah, it's a quirk of how you just substitute retail customer, retail client for investor, and that's the standard.
But I mean, it relates to the delivery obligation prompt. I mean, Reg BI disclosure is obviously at or before the time of a recommendation.
Right.
If you never make another recommendation to that client, even if your business changes in the future, you don't have to go back and update your Reg BI disclosure unless you're going to give them a recommendation in the future. But Form CRS is different. I mean, you've got 60 days, I think, if you have a material change to your Form CRS, the first, the first layer. I think you do need to deliver to all your existing clients within 60 days, right? Isn't that part of the obligation?
If you make any change in it?
Yeah.
I think it was material change.
Yeah, material change. Yeah.
Back to materiality.
Yeah.
Anybody else? We have another couple minutes. All right. Finished early.
1 minute.
One minute.
Just still the 1 minute. There we go. All right. Thank you
Well done.
so much. Thank you.
You guys like that person.